lot of visual stuff in my slides, and maybe, at some point, if I have to, I'll turn my laptop around to show you what I intend to show. Here we go. I was here 9 years ago, in 2016, and you all got older. No, I was probably, it was probably 2014 or 2015. I went to a symposium in Washington, D.C. of intellectual property lawyers, and it's 8 o'clock on a Friday morning, and everybody's bleary-eyed, and there was a young lady that had a presentation on gene splicing therapies and patentability of portions of a genome. And she was absolutely crippled because her laptop wasn't working, and all of the slides that she had meticulously prepared, she couldn't use. So this kind of reminds me of that. And but I thought, when I prepared for this, I said, well, I've got my old presentation. How many people are going to be there in 2025 that weren't there in 2016 and vice versa? But I did a considerable amount of work updating and changing and modifying and reflecting on this association and the points that I wanted to make. I had a background slide. I went to high school on the west side of Cleveland. I went to undergraduate school on the east side of Cleveland. I went off to Yale University to get a PhD in chemistry, and then I went to law school at Case Western Reserve. So in the Reaganomics era, I was a gifted student and enjoyed Reaganomics covering most of my education. In 1982, when I graduated from law school, I was admitted to the bar in Illinois and 85, Ohio. I'm a member at the U.S. I'm a practicing patent attorney at the United States Patent and Trademark Office. I've been admitted to practice in multiple United States district courts, including Ohio, Illinois, New York, New Jersey. I've practiced before the International Trade Commission in Washington, D.C. I've practiced before multiple United States Courts of Appeals, including the Fifth Circuit, Sixth Circuit, and just recently I was admitted to the United States Supreme Court.
Say that again.
United States Supreme Court.
Congratulations.
Thank you. Thank you. Yeah, thank you. My historically, okay, so out 82 to 2025, that's 43 years. I would say 95% of my career was devoted and has been devoted to pre-litigation and litigation and trial work. Somewhere around 5% of my career has been devoted to protection of intellectual property, and it's probably less than 5%. But I'm still admitted to practice before the Patent and Trademark Office. I've procured patents, trademarks, and copyrights for clients, and so I know the ins and outs at the Patent Office. I can read the regulations and follow them. Upon talking to Charlene, I think, maybe it was you.
By phone.
By phone. I decided it didn't make sense to talk a whole lot about patent protection and trademark protection, but I am going to do a mini survey by hands just to make sure that I'm going the right course here. So I'm going to minimize what I would ordinarily say in a general lecture about patents and trademarks and focus on copyright, because I think that's, in terms of your intellectual property, your desire for protection for intellectual property, I think it focuses on in the copyright area, with some limited exception, and I'm going to talk about that. But the survey is. Raise your hand. Is anybody involved here in the performing arts? How about photography, digital or film photography?
Yeah.
A little bit?
Mm-hmm.
Okay. How about design, fashion design? Anything? No? And so the vast majority of you, fashion?
Well, a little bit.
A little bit. How about mixed media? Do any of you use like photography and art, brushstroke art? Yeah, okay,
That's possible.
yeah,
Yes.
combination. So the vast majority of you are devoted to what I would call the fine arts, right? Painting and sculpting?
Yes.
I'm getting a lot now,
Yes.
okay. How about any other areas that I haven't covered? Any other kind of art that I didn't mention? No? Okay. Now, how many of you own your own business? Just the two of you?
I think it's much.
You?
Four.
Three?
Or
Yeah.
five.
And to the extent you're willing to say, how many of you are selling or thinking about selling or licensing your artwork? Everyone? Okay. How many, does anybody have a dedicated gallery for their artwork? No. Okay. All right. And how many of you are concerned about competition and intellectual property? Every hand should go up. How many of you own a trademark? Anybody? Do any of you hold registered copyrights? Show of hands. Nobody? Okay, well, I'm going to tell you how to do that. And you can, believe me, it's easier than the simplest tax return you've ever done to file and register your own copyrights. Now, you might genuinely ask, why should I do that? And we'll talk about that. Okay. Okay, when I talk about intellectual property, typically I'm talking about the federal schemes of intellectual property. Patents including design patents, trademarks and service marks, copyrights since 1976, and trade secrets and possible misappropriation and unfair competition. There are obviously state schemes for intellectual property that are independent but dovetail with the federal schemes. And for example, trademarks. If you have a business, you've registered your name with the Secretary of State. That serves a trademark function. There's also state law of trade secrets, unfair competition, misappropriation, rights of privacy, rights of publicity. These are state rights. So what happens here in Ohio is quite different than what happens legally with respect to rights of privacy and publicity in states like New York or California. So where you are, where you are and what happens where you are determines what law controls. And Ohio does have a much, comparatively speaking, much less developed body of law when it comes to things like right of privacy and right of publicity. And the other state-related element that I do want to spend a little bit of time with you talking about tonight is the impact and ability of each and every one of you to use contracts and or licensed language in connection with protecting your intellectual property. Okay, I'm really going to briefly talk about patents. Patents, Article 8, Section 8, Clause 8 of the Constitution give Congress the right to legislate in the area of patents. So it's a federal scheme only. Patents are, let me just summarize. Patents live for 20 years. 20 years from the date you file your application, or 17 years from the date of patent issuance, whichever longer, figure 20 years. Copyrights are not, copyrights do stem from the Constitution, but they stem from the, it stems from the same section of the Constitution, Article 8, Section 8, Clause 8, where Congress the Constitution talks about securing the rights for artists and inventors, the exclusive rights to their inventions and works. Copyrights last your lifetime plus 70 years. So it a long time relative to the expense of getting one. Trademarks stem from the congressional, Congress's power to legislate in the area of trademarks stems from the Interstate Commerce Clause, a completely different animal. But trademarks last theoretically indefinitely as long as you continue to use them in connection with your business and you continue to pay your regular fees at the trademark office and continue to make regular filings demonstrating continued use in interstate commerce. So
it's pay to play.
Pay to play. Yeah, and that's especially true in patents. And I had two examples of design patents. One, an image of Augustus Bertolli's Statue of Liberty. That was protected by a design patent, and so was Apple's iPhone. And you can pull this up if you type in Google patents, and the number is D618677. Apple sued Samsung and claimed infringement and won, I believe. They either won or they settled the case. Design patents protect the ornamental aspects of a thing, right? And as distinguished from the functional aspects of a thing. So it's a way that artists like Bertolli protected the Statue of Liberty. You too could protect, if you have a sculpture, you could protect that using a design patent for 15 years.
I have a question. Okay, the Statue of Liberty, you said, is protected with the patent, correct?
Design patent.
The design patent.
And that falls under patents.
Patents.
Right.
Right.
Okay, so, say for instance, if I wanted to do that, do the Statue of Liberty on T-shirts or whatever and make money off of that, is that legal or illegal?
Now it is because the patent's long expired. It's in the public domain. But yeah.
Okay,
yeah.
but if it was something recent,
covered, yeah, you'd have an issue.
I would have an issue.
Yeah.
Okay.
Yeah.
But you know what? I see a lot of that out here.
Oh, you do. Yeah,
Oh, yeah.
everybody does.
Yeah, it seemed like,
It's,
people don't care, they
and
just
from
take it.
from a plaintiff's lawyer perspective, when you get involved in things like T-shirts, and we'll talk a little bit about that,
Right.
and the internet,
Mhm.
it's you wind up playing a game, we call it whack-a-mole. And it's whack-a-mole, because every time you whack one, another one pops up.
Exactly.
So my message to you is, unless, you come up with an earth-shattering idea that you think is, novel, not obvious, and useful, you're probably out of the patents game. But if you're in the patents game, there's no substitute to seeing a patent attorney registered to practice before the patent office. There are no online shortcuts. And I would say the same thing is true for trademarks, but people try. And you see stuff online all the time about protect your trademark, $49. Don't do it. Don't do it. It's garbage in, garbage out. Now, one note, there is a procedure at the U.S. Patent Office, an inexpensive procedure if you think you've got the next best thing since sliced bread, called the provisional patent application process, where you make a filing that looks like a patent application, but in fact it's just a provisional patent application. You file your notes, you file your drawings, and you pay a minimal fee to get the ball rolling. What does that do? It protects you, it stops the clock from running, it allows you to commercialize your invention and see if there's a commercial need for your invention for a 1-year period, and then you have to go and file the regular utility patent application after that. So if you do have a discovery, the cheap and dirty way to go is to file a provisional case and see if there's a market for what you've discovered for the next year. But go see the patent lawyer within give them a 2 or 3 month window to file your full utility case. So 9 months, but that's considerable help.
Does that price vary?
Pardon me?
Is it one set price or does it vary depending?
The filing fee is the same. It's one
It's
set
still the
price.
same. Oh,
Yeah,
okay.
and the lawyers, lawyers charge
I was gonna say
whatever
lawyers would be
whatever
different.
they charge.
Right.
You know what I say about lawyers? It's the 99% of us that give us all a bad name. So, okay. Damages in a patent infringement case. I mean, the question of infringement is, does the competition, is he making, using, or selling a device or method that falls literally or equivalently within the scope of my claims? And then if you prevail in a case, you're entitled to a reasonable royalty, lost profits if you're a competitor, and if you can demonstrate willful infringement or malicious infringement, or in any other exceptional case where the lawyers misbehaved, you can get enhanced damages and attorney's fees. All right, let's talk about one thing of note in patents, and this is new since 2016. AI and invention. Okay, there's been several cases where an inventor used ChatGPT. Stephen Thaler used ChatGPT, and he named, Stephen Thaler created DABUS, D-A-B-U-S, device for autonomous bootstrapping of unified sentience. Okay, he trained 2 AI systems, first trained with data from a particular scientific area and used to generate novel alterations to that data, and the second developed to measure the novelty and utility of the alterations created by the first. Okay, he created 2 applications, submitted to the patent office. They were rejected by the Patent and Trademark Office on the grounds that no human was named as the inventor, and the review board upheld the patent examiner. He then appealed to the Eastern District of Virginia and wound up in the Court of Appeals for the Federal Circuit, who all affirmed the rejection. He petitioned for a writ of certiorari at the Supreme Court, which is the only way he could get to the Supreme Court. And in late April, the Supreme Court refused to hear the case.
Okay, so summarize again, what did this guy do? I mean, I like.
Well, he used AI.
Okay,
He used AI to
create
come up
something?
with
An invention of some
an
sort?
invention, right?
Not an art.
And
Not an artwork, but an invention.
an invention,
Okay.
right? And he submitted it to the patent office, tried to get patent protection for
Okay.
the invention that AI generated. And
No.
the problem with this case is that the Constitution talks about inventors
Inventors,
and
not machines that invent.
and he contended that Congress did not include any restriction on the word inventor or individual to pertain only to natural persons. He was wrong. The courts disagreed. Individual ordinarily means a human being. The Federal Circuit has held previously that inventors must be natural persons.
Natural person.
Right. So the answer is, the Patent Office has emphasized that the human must make a significant contribution to an invention for it to be patentable. So patent law requires inventors to be natural persons. You know, the human must make a significant intellectual contribution to the invention.
Create it, and then you just have to tweak it enough to make
Right.
it yours.
To make it yours. Now, with
Inventions developed with AI assistance can still be patentable. You can't, you just can't claim that AI was the sole inventor.
Oh,
And
that's
the,
interesting.
you
That's
know,
interesting.
and the key here obviously is that the human must make a significant contribution.
Right,
Can't
right.
be so.
I have a question.
Yes,
Now, if you flip this and you know, with this AI art that's really popular right now, how does that apply to AI art?
we got.
And does
it's
the
coming.
artist actually have ownership of that artwork since it was created
In March.
by AI?
In March.
Unless, I
in
guess.
March, the Copyright Office addressed that.
Oh.
And I've got the circular, and you can pull up the publication. I think it's 50-something
Yeah, 'cause
pages.
that's like on the rise.
52 pages of an opinion, and it will give you the guidance you're looking for if you're using AI in connection with your art. But, okay, so trademarks for you business owners, you know, a trademark is, you know, normally a logo, a design, a word, or a phrase. You know, Golden Arches, KFC, the Colonel, an apple with a bite out of it. You know, that's all. Those are all trademarks, and slogans. You know, Built Ford Tough, example. But almost anything can be a trademark. Shape of goods. The Coca-Cola bottle is protected by trademark. The Tiffany colors can be protected. The ones that come to mind, Tiffany and Company's blue, Owen Corning's pink. Mercury Motors tried to protect black for boat motors, and they were rejected. It was too commonplace. Patterns are protected, like the Burberry pattern on the lining of a Burberry jacket. Even smells and sounds have been protected. Plumeria for sewing thread is protected.
You've got mail.
That's protected. Sounds are protected.
Sounds. That's interesting.
Anybody Anybody know what that is?
MGM.
MGM.
Hmm.
And one that everybody should know.
Sound like anybody.
NBC.
Somebody said NBC.
NBC.
Oh. And
Cartoons. Cartoons.
that's, so trademarks can be anything. That's Time Warner's, Looney Tunes. They're all trademarks, and you can't copy them without getting the wrath of those large entities against you. What does a trademark do? It identifies your source. It identifies you as the source of a product or service. It assures the quality of a product or service. It creates and maintains a demand for your product. It represents your business goodwill. How do I obtain trademark rights? By use. For you business owners, if you don't have a registered trademark and you're selling products in interstate commerce, you may consider filing. You know, it's not real expensive. I've got a table here at the end, and I can tell you what the number is to get trademark protection. But unlike patents, where you don't have any protection absent filing a patent application at the patent office and getting an issued patent, trademarks are a creature of common law. By my holding myself out as Michael W. Very Consultant, I've created a trademark. I put it on my logo, I put it on my business cards, I put it on my letterhead, I put a sign outside my office. I've created a trademark. Whether or not, I registered it with the state of Ohio, but whether or not I ever get a federal trademark, I have trademark rights. They're regional. They're within the region of my reasonable customer base, but I could pursue a claim of infringement if somebody else came along and wanted to call themselves Michael Very Consultant. So trademarks are created by use. It's hard to get your mind around, because there's no trademark registration requirement for you to sue in state court. If somebody came along and took your business name and moved into your territory and started selling products similar to yours, you could go after them, for you business owners. And it's a state law claim. You'd be in state court, but you can claim that, somebody's infringing my trademark, somebody's misappropriating my goodwill, somebody is palming off or trading off on my reputation by using my name. So it's available to you. You don't have to have a federal registration. But if you have a significant number of customers coming in from out of state, and you have a good claim to make a claim for interstate commerce use of your trademark on goods and services, seriously consider getting a federal registration. Benefits of a registered trademark, validity is presumed. It's constructive notice nationwide of your claim of ownership, and you can employ the jurisdiction of the federal court system on claims of infringement. And it's also can be used as a basis for filing and procuring international protection. If you're using a trademark, if you use what you claim as a trademark and it's not registered, you should use superscript TM, uppercase TM, Michael W. Very Consultant TM. There's a circle R that's limited to registered trademarks only. So you can't use the circle R. If you are providing a service, use SM instead of TM in the superscript. And again, circle R is limited to registered trademarks. skip over trademark infringement. You know, famous trademarks. Famous trademarks that you all know, McDonald's, Burger King. Maybe I can turn around my, I don't know if I can.
Trademarks would also include like your signature on your artwork too, if you have a special way of signing your signature. Would that be
Yes.
considered a trademark?
Yes, it could be. You can protect the words of your name as well as the stylized use of the words.
Right.
Okay, I don't know how well you can see this, but this is something, why is it, it flip slides when I turn it around.
Oh.
Back. I'll go back. No. Yeah, there it is. Okay, I represented a little winery on the eastern border of the state of Ohio. They manufactured a wine called Purple Rain. And the estate of Prince, who has an album and all sorts of stuff that labeled Purple Rain, came after us, came after the client. And I will tell you, the punchline was it was settled. Purple Rain, there are two trademarks out there that kind of above all other trademarks in the entertainment area, Purple Rain and Margaritaville. And I've had cases for defendants on both recently.
So what was the trouble with Purple Rain?
What we settled, after years of wrangling, we agreed to withdraw our product from the market. They gave us a sell-off period, and what I would consider a very small amount of money changed hands.
So who did you infringe on? Somebody called Purple
Prince.
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 Prince?
The
Why-
singer.
Why Prince and Purple?
Well, Prince is,
Oh, God,
Prince
I
is,
don't know. I must
that's
be
all right.
way out of it.
No, Prince,
Out of my realm.
yeah, well, that, you would have been very useful to have in our customer
Yeah,
survey.
Purple Rain.
Purple Rain, yeah.
I don't know
There-
what it is.
The estate of Prince argued that Purple Rain and the persona of Prince are so intertwined
Singer.
that by labeling any product Purple Rain, you're evoking the image of Prince in your prospective buyers'
Gotcha.
minds. So the argument is that somebody seeing a bottle of Purple Rain wine, would
I think it was.
naturally assume that Prince is somehow associated or affiliated with your product.
Or, yeah, or endorsing it.
And they did surveys showing that, you know, 70 to 80% of the consuming public,
Would you call it
would-
Purple
would-
Raindrops or something
yeah,
like
yeah,
that?
Is that
yeah,
what you changed it?
that they've changed their product name and labeling.
They had to change their name?
Pardon me?
They
They had to.
changed their name?
They have changed. Yeah, so you might be able to find an isolated bottle or two.
Yeah.
It's got a screw cap and they're sold at Get-Go and Walmart. It's not a high-end wine,
Yeah.
but it's a high-volume wine. They did a lot of business, and you might, the sell-off period is over, so we're not allowed to bottle or label any more wines. My client, and all his inventory and labeling and things like that should have been destroyed by now.
What's he
Yeah.
calling it now?
Oh, he's, you know what, it's purple something, but I remember one of the terms of the agreement was it couldn't be purple mist. It had to, it's, and I don't recall, but the name of the winery, if you wanna look it up, is Lovabella Winery. It's L''UVA, Bella, Bella wine. Now, if you search on Lovabella wine, if you have an internet connection, you can find these images of Purple Rain wine, because things on the internet never go away.
Yeah, right.
And, you know, it's one of the things that intellectual property lawyers despise about the internet, because you can have a great victory or settlement agreement and the stuff is still out
Still
there.
out there.
In fact, you know, I've got another example that from my own practice that I'm gonna talk about. Okay, Jimmy Buffett. Jimmy Buffett came after another of my clients a few years ago, and it's hard to see, but this is Jimmy Buffett's mark for Margaritaville, and this is my client's mark for Barkeritaville. He was my guy in Key West, West Palm Beach, Florida. Operated a doggy daycare and spa that he called Barkeritaville. Well, Jimmy Buffett and his agents sued and challenged our attempts to get a federally registered trademark for Barkeritaville. It too was settled, and Jimmy Buffett paid a considerable sum of money to us to turn over the brand and rebrand. So that's not unusual to be on the defendant's side and be victorious in the sense of you're getting some money to rebrand. Because the plaintiff wants you to rebrand, and you don't have necessarily the money to rebrand, but so you ask as a part of the term of settlement, you're going to stop doing what you're doing, but you need help financially, and so that was Jimmy Buffett. The Louis Vuitton bag reminds me of a famous trademark case involving a company called Hout Diggity Dog, that made a product called Chewy Vuitton, and Louis Vuitton sued Chewy Vuitton and lost. The court found that there was no dilution, no infringement.
Oh my goodness.
Is there something you can check before you decide on what your patents?
Yeah, that's kind of where I'm headed with this. How many of you I know at least one of you has a website, right?
We have a website as an organization.
But what about individuals? Do any of you individually have a website? Are you selling any products on the website?
Some of them, yes.
Okay, there is, we talked about this.
Right, I talked to you.
Yeah, okay, all right, yeah, you don't have a problem. I had a client who had a problem, and we went to trial, and this was right before I gave my talk. A year before I gave my talk here the first time around, I was in front of a jury in Miami. The world's richest man sued my little Middleburg Heights woman for infringement of his trademarks having to do with cellular phone products. And what she had done is she got very clever with respect to her choice of URLs, and she embedded the name of the product in her URLs, and she was outselling the manufacturer of prepaid phone cards, and they didn't like it because their marketing guy was suffering, you know, all sorts of backlash because he wasn't selling as well as she was. There's a very famous case out of California, Toyota versus Tabari, involving the sale of Toyotas, and Tabari had a dealership, a Lexus dealership, and he put the word Lexus in his URL, and the court, the case that's written is very well done. It explains, you know, do's and don'ts when it comes to your selection of URLs and you're selling a product. Obviously, you know, www.lexus.com is the company site, but what about www.lexusbroker.com? I mean, it's truthful. It's what they were, and so Lexus, you know, there's the decision is very useful for giving guidelines with respect to your selection of a URL. I'll only say that. Toyota versus Tabari, if you're interested. typical remedies in a trademark case: damages, injunctive relief, destruction of the products, and for willful or malicious infringement, enhanced damages and attorney's fees. How do you minimize the trademark risk? When you adopt a trademark, the easiest thing to do is to go to the Patent and Trademark Office site, and this has dramatically changed in the last, I would say, 5 years. The USPTO website has gotten very user-friendly. They've got a lot of tutorials on how to do searches, and give you
What website
an
again,
elaborate,
the PTO?
United States Patent and Trademark Office, the uspto.gov website. And it tells you all about trademark fundamentals. There's webinars there, and there's a search website that you can link to. And they've, in the last 2 years, they changed the name of it, but it's linked right off the United States. Don't be fooled. If you type in trademark search, you'll get a lot of these fly-by-night organizations that'll do your trademark search for $45 or whatever. You can do it yourself for free. And that's all they're going to do. They're going to get on the website and do a search, and it's simple. I would encourage you, if you're thinking about a business name, to explore several options. Do searches on all of them and decide. And I say the sooner the better. You can always adopt a name, and if you get that nasty letter from the law firm in the mail, you can drop it and change it before you've invested a whole lot of money. Or you can spend, I would say, several $100s, maybe $1,000 with a lawyer and get kind of the pre-clearance go-ahead. They'll do a more elaborate search than you can do, but it's worthwhile if you're starting a big business and the name is important to you. Yes.
Question. If EuclidArt.com had an interest in purchasing another URL, or if somebody had this URL, like EuclidArt.info, would that be a case if somebody else had EuclidArt.info and we are EuclidArt.com?
Right. It could be. It could be if they're diverting your traffic.
Right.
The other thing is ICANN is the government agency or quasi-government agency in Washington D.C. that polices URLs, and you may have to pursue a communication with them to sort that out.
Right.
But,
Okay.
yeah. Okay, let's talk about copyrights because
Yeah. Sounds good.
I spend as much time as necessary on trademarks and patents. Okay, copyrights protect original works of art. Literary works, musical works, dramatic works, choreographed works, pictorial, graphic, and sculptural works, motion pictures, sound recordings, architectural works, artworks. Copyright is similar to trademark in the sense that by publicly displaying your work and offering your work for sale, you automatically have copyright rights, okay? The only thing you don't have is a registration. And if you, on the art, on the work of art or on a label describing the work, you should have your name with the word copyright. Copyright Sue Harris, 2025, all rights reserved on it. Okay? And you
That's
can,
on any piece of artwork?
any
you
piece,
say?
any
Even
piece
the
of
original?
any piece of your original artwork. If you have a label,
Right.
put your name, copyright 2025, all rights reserved.
You mean on the back of your artwork? You're certainly not when you sign your artwork.
Right.
You're gonna
On
do
the
all
label.
that.
On a label, on a label affixed to the artwork.
Original and prints?
Yes,
Oh, okay.
yes. Prints, if they're original, they're entitled to protection. If they're prints, they're considered derivative works.
So it would be copyright, you say your name, say copyright what?
Copyright 2025, all rights reserved. Now, copyright has statutorily a body of exclusive rights associated with it. As a copyright owner, you have the rights to reproduce the work, make copies, prepare derivative works, distribute copies, and, for movies and things like that, perform the work, plays, perform the work publicly, but for artists, display the work publicly. And I want to talk a little bit about that. The reproduction right grants the copyright owner the ability to control the making of a copy of the work. It is arguably the most important of the rights as it is implicated in most copyright infringement disputes. Some examples of activities that implicate the reproduction right include the pasting a news article into an email, photocopying a magazine, uploading movies or music to a website, copying a computer program or document onto a PC, scanning or digitizing printed text or images into a digital file, or right-clicking on an online photograph or other image and copying it and saving it to a PC. So, but those are your exclusive rights as a copyright owner. If somebody else does that, that's an infringement. That's true of all your exclusive rights. If you do it, that's your right. If somebody else does it, it's an infringement unless they have your permission. Derivative works for you all is equally important. A derivative work grants the copyright owner the ability to control the modification or adaptation of the work into new works. Derivatives can include annotating, editing, translating, modifying, or making other changes to the work. So if you have one piece of art and you're doing a series, and let's use the blue palette on this one, but let's use the red palette on this next one, but it's the same underlying image. Those are considered derivative works of each other, and that again is your exclusive right. And if somebody else does it, somebody takes your blue artwork and turns it into a piece of red artwork and otherwise copies it, that's an infringement. The right to distribute copies grants the copyright owner the ability to control the manner in which a work or a copy of work is transferred to others, whether by sale, rental, lease, or lending. Nobody else has that right other than you. The display right, which is important to you, it's important for several reasons, but we'll talk about the application process in a minute. The display right only applies to the following types of works: literary works, musical works, dramatic works, choreographic works, pantomimes, pictorial, graphical, or sculptural works, including stills from motion pictures and other audiovisual works. The public performance right is different. It only applies to literary works, musical works, dramatic works, choreographed works, pantomimes, motion pictures, and other audiovisual works. What does it mean to publicly perform? This was a huge area of litigation in the Betamax VHS era. When I first started practicing lawyer in the 80s, because when VHS copies of tapes came out, they were intended for personal use only. You buy the tape, you go home, you show it in your living room to your family. People were buying the tapes, they were setting up little kiosks and playing, people would go to, it's like a mini theaters where they have little kiosks set up and you could watch a movie. And so the question was, or if I plug a VHS into one of these devices and play it for you all, am I publicly performing a work? In general, a display is considered public when the work is displayed in a public place or a place where a substantial number of people outside the normal circle of a family and friends are gathered, or a display of the work is transmitted to the public. That statement of the law comes from the VHS tapes days. And the test was, well, are there people, are people, they'd ask, but it's not just positive, are people paying a fee to see this? And are they people outside the normal scope of a family unit watching? And, there's a lot of cases out there on that, but, I have some examples of public displays, and I don't know how well you can see that, but this I took on my way down south about a month ago at Tamarack, and there's a really clever artist and with mugs and jugs with human faces on it. It's really wild art. This was taken at the John and Mabel Ringling Museum down in St. Petersburg. Can everybody see that?
Mm-hmm.
That's Romulus and Remus and the she-wolf. The Romulus and Remus, the mythical founders of Rome. But those are public displays. A public display is a display of your art for sale, okay? It's considered a publication of your artwork. And I say sale meaning sale, lease, or other disposal. And to whom? The general public. It can't be just to family and friends. It can't be a limited offer of sale
Like our
to
art shows,
family
we
of
just put up
friends.
an art show over the weekend.
Right, all your art shows are perfect.
And they're all
and-
for sale.
right.
Or not, or they say they're not for sale. There's a price on them.
It's an option.
It's an option.
That's the, I don't want to sell it price.
Yeah.
If you've got a
Yeah,
piece of art that you really don't want to sell, put the I don't want to sell it price on it and put it in an art show. Okay, now you have satisfied one of the requirements for getting federal copyright protection. And you need to keep records of these dates. When you first show your art and have it labeled for sale to the general public, it's considered for a piece of art the publication date. And
No.
anyway,
That's good information.
so what does a copyright protect? Copyright protects the expression of an idea, not the idea itself. And the example I always use is, I'm not much of an artist, but I could try to draw a Mona Lisa, right? And, a woman on the hillside is the idea. And my rendition of a woman on the hillside doesn't look anything like Da Vinci's Mona Lisa, right? If there was a copyright still on the Mona Lisa, they couldn't sue me for infringement because they're trying to protect the idea of the woman on the hillside, not the expression of the idea, which was my workmanship versus their workmanship. The key element of a copyright, it must be affixed in a tangible form of expression, like you do when you paint your paintings. It must be, there is an element of originality to it. And for example, if I come up with a spreadsheet, a way of spreadsheeting business expenses, I can't copyright that spreadsheet because there's no, and there are cases about that. There's no originality there, and it's perfectly utilitarian. Table of weights and measures, accounting spreadsheets, calendars. They're not, minus the artwork, calendars themselves. They're not copyrightable because there's no originality. And copyright, contrary to popular belief, does not protect slogans, short phrase, titles, or names. I'm not gonna. There's a lot of examples, and I used them in 2016 when I spoke here about musical work, infringement of musical works. The,
Now, what is
the best example, go ahead.
oh, okay.
I was just gonna give one example.
Oh.
I mean, there's Freddie Mercury and Vanilla Ice was one good example, but you know, Vanilla Ice in 1990 came out with the song Ice Ice Baby.
I love that song.
And this is a minute or two to give us all a break. I hope you can hear. This video is made to prove how Vanilla Ice's biggest hits, Ice Ice Baby, is an infringement of Under Pressure.
Use it.
It's, you,
Oh.
when you hear it, you think it's, oh, which one is that?
I don't know if you could hear that. That was Under Pressure.
I think both of them, Under Pressure.
No, I'm killing it every time I do
Yeah,
that.
I remember this song. Both of them.
Back. I'm trying to turn up the volume, but it's not cooperating.
So you're a DJ too?
Yeah,
That's your side job.
there we go. This is the first 30 seconds of Under Pressure.
So it was like in the early 80s, I think.
So what about this one?
Yeah, well, the infringement's coming up, the alleged infringement by Vanilla Ice.
So this was David Bowie, I believe.
All right, this is Ice Ice Baby.
Ice Ice Baby, I think, was 1990.
Yeah.
There's an extra note in there.
I get disappointed when a song comes out and it's not the one that I want.
Right.
Yeah.
Okay, so Vanilla Ice confessed to sampling the work by Freddie Mercury.
So
And
what happened? Like you still hear
the
it?
case was
Oh.
settled out of court for a undeclared sum of money, but Vanilla Ice credited David Bowie and Queen on the track, so that was the settlement.
Yeah.
For example, you said you can't do a slogan, like if you use, it's the real thing.
Right.
Coke's famous saying,
Mhm.
Coke, it's the real thing. You can use it's the real thing and use it for something else and no problem.
Well, I meant to mention that. The United States trademark system is based on product classifications. So you can have, the word United can be a van line company in one class, and it can also be an ice cream company in another class. So the question is, is there an overlap sufficient that consumers might be misled as to the source of the goods? And the trademark office looks at that. Now, you know, with Coke, that Coke slogan is such a famous trademark, you probably can't use it in connection with other products. The Patent and Trademark Office would not allow that to be registered because of the fame of that slogan. But there are other slogans, it's a real good thing, it's a going thing. Now, there's
It's
other.
different enough.
There's other slogans that are used commercially that are very similar. I can't remember the companies that use those slogans, but those are examples. It's a real good thing. It's a real thing. It's the going thing. Those are all slogans of companies.
We have a few minutes.
A few minutes. Let me let me,
about
let me jump forward a
5
little bit.
minutes.
5
And
minutes?
do you mind us asking you a few questions about, like, if anyone has questions
Absolutely.
directly about their artwork?
Yes.
Anybody have any questions directly about their artwork and legal issues or copyright?
Let me just, before we get there,
Okay.
let me
sure.
make this very important point. AI cannot be a sole artist or author, okay?
That was-
January 29, 2025, this is a very,
That's a good one.
this is, the U.S. Copyright Office released part 2 of its artificial intelligence copyright report. It addressed the human authorship requirement. AI can be used as a tool, but cannot be an artist or author. AI is considered a tool used by humans in the creative process, but not the creator itself. Works solely generated by AI are not eligible for copyright protection.
So if you
Oh.
create artwork with AI, do you have to divulge that information
That's a good question.
that you did it, that you created it?
I've
that
not
way?
looked at that, but normally at the Patent and Trademark Office, there's an obligation of candor by the lawyer at the Patent and Trademark Office. So I've never looked at it. I
'Cause I
If
know
you
that-
used, if AI was not the sole generator of the piece and just used as a tool by you, there is a application and review process of your copyright application, and I think it's fair to say that you want to divulge that in the application process, just to be above board on it, and maybe you can explain to the copyright examiner the role, the amount of your input versus AI's input in the piece. There was one other thing I wanted to say to you all, as artists, and this is all development since the last time I spoke, but I represented the longest the longest family-run business in the United States, longest continuously run family business in the United States, which started in 1623 outside of Richmond, Virginia. It's called the Shirley Plantation, and if you do a search, you'll see the images. They have signage, and this is the point I'm making is when you display your artwork, you should be thinking in these terms. They have a sign that says, "Visitors may take photographs or make illustrations of the buildings and grounds of Shirley for personal use only. Photography and illustration is not allowed inside the Great House. Commercial uses of photographs or illustrations are prohibited without express written consent. By entering Shirley Plantation, you agree to these terms." Okay, so what happens? People get a hold of the picture of Shirley Plantation and use it as a backdrop for their scandalous books, A Life Worth Defending. A guy's standing there with an AR, a wife and his child, and a rough-looking guy. But that's Shirley Plantation in the background. Anyway, so needless to say, we went after him and got him to stop. And just this is the main house at Shirley Plantation. Yeah, it's quite a place to visit. Charles Carter is currently running it. He's a little younger than I am.
Do you
Anyway,
suggest,
pardon me?
do you suggest that we,
Yeah.
before we draw or sketch something?
Yeah, you should
that
have a
we should
sign.
get
I think
permission?
you should consider a sign at every time you display your artwork. That any obviously you don't want people using flash photography on your works, but prohibiting flash photography and any photography other than strictly for personal reasons. And you don't want them uploading your images to Facebook and stuff like that, right? So you can say that. You can have, by entering this gallery, you agree, because it's a license. They're coming in, and there may not be a charge, but you're telling them, you don't want these pieces of artwork photographed and disseminated outside of the control of the artist. It's not fair to them. So, you know, if they do take, you know, the other museum I went to when I was down there, I went to the Dali Museum, which shocked the heck out of me because their only restriction in that big museum in St. Petersburg is no flash photography. In fact, they encourage the use of smartphones in connection with Dali's artworks, and I don't know if anybody else has ever been there. But, you know, yeah, some of his artwork is best viewed with a smartphone. And because of the way Dali embedded images within images. And, you know, this would have looked much better on the big screen, but you probably can see that from a distance, you can probably make out who that is, right?
Yeah.
Now that, on my left, your right is Abraham Lincoln. And there is, you know, if you zoom in or look carefully, there's quite a few embedded images in there. And the image on my right, your left, looks like a human ear, but inside the human ear is a Madonna. And what they encourage you to do is to take a picture, or, you know, squint your eyes a little bit, and the, you know, some of the images become clearer. But I was surprised that the Dali Museum did not have a restriction against taking photographs of any of his works of art. You know, he passed away 10 years ago, maybe. So his copyrights are still good for another 60 years. So this is all copyright protected stuff. So contractually, you should consider having a sign when you enter any of your displays of your artwork prohibiting photography for any purposes other than for personal use. Images are not to be uploaded to any websites. Images are not to be shared on Pinterest, Etsy, or whatever, you know, clip art sites you can think of, or any other clip art site, you know. And that, as an aside, don't use clip art. Or if you use clip art, make sure you follow the parameters of clip art, the clip art. I represented a guy who used some clip art in his business presentations to a corporate-wide presentation. And it was discovered, I don't know if you've seen these, that, you know, they look like road signs and curves and stop signs, and, you know, somebody made that clip art. And they say, you know, you're free to use this, but don't make public displays of them, or don't use them commercially, you know. Well, this guy used them in what's considered a public display, corporate-wide. And we had to resolve that.
So even if it's marked on the website as free clip art, you can't?
Oh, well, read the fine print. Read the fine print. If you really believe, yeah, I would be terms of use. Read print the terms of use and study them before you use the free clip art. Yes.
I mean, who's gonna read that detailed stuff?
I was just gonna say, it's so
Pages of
small.
This isn't clip art, but interesting, like, you can go to the Cleveland Art Museum, and most of the time, you are free to take pictures of anything you want in there. They specifically, someone special, they'll say you can't take a picture of these certain, they'll have it on specific pictures if it's one of their exhibits,
Yeah.
you know, but the others that aren't blasted like that, you can take pictures, not flash,
Yeah.
but as long as it isn't flash, they don't.
Well, some of the artwork that's longer than the life of the author plus 70 years is no longer subject to copyright
Oh, I see.
protection. So it's right. Yeah, Rembrandt. You know, I mean, they're in the public domain. Da Vinci, it's in
Yeah,
the public
most of
domain.
them are way older.
Right. So they're older. Yeah.
So in other words, the Mona Lisa, you can't copyright that?
Right. No, it's out of copyright. Just like some of the earliest Mickey Mouse movies are now in the public domain.
I see.
D.W. Griffith's Birth of a Nation. It's in the public domain. You get a VCR copy for $2. Probably get a DVD for $2.
Wow.
That's way too much.
Well, thank you. Thank you for listening.
Very much.
Thank
Yeah.
you so much,
Yeah.
Tony. We learned quite a bit. We learned quite a bit.
Well,
Yes, that was very informative. If anyone needs to follow up with him, I'm sure you have contact information that we can
I do.
forward, right?
I do.
Or business cards, okay. So if you want, yes,
Oh, excuse me, I don't wanna interfere with that. I was asked to run an errand and I had some announcements.
oh, okay, you want to say something about the spring art
Finish
show?
up with what you wanna do.
Okay, yeah. So, as I was saying before, there's business cards here available if you have any, follow-up questions or things that you're concerned about with your own artwork. Feel free to reach out and get a card. Okay, everyone, I know you're ready for
I
refreshments,
think so.
and don't run too fast over there.
I'm gonna
Everybody's
take,
still sitting. But, yeah, Ellen has to talk about the spring art show real quick.
okay,
Thank
first of
you.
all,